Supplemental list, item number 1.
Yes, Mr. Naik, you wanted?
Yes. Associate have to virtually completed the very minor, you're also directed to submit a note. So,
No, you yesterday you made a mention that you want to.
clarification, my lords, since this petitioner, this appellant, there are two appellants, my lord.
Yeah.
Both of them were convicted under section 302 by 34.
Right.
So for the other appellant is concerned, my lord, the finding about him that he along with these petitioners might have killed, or they have been, both of them have found 302 by 34 IPC. So in absence of him, can I be alone convicted under section 3?
No, he has not been, the conviction is not set aside. He has been just released, the remission period. So the conviction remains that. If even
that stands.
Sir.
Probably the remission can only be considered after the appeal is disposed of.
No.
During the pendency of the appeal.
Yes, is that.
Yes.
So if there can be a conviction on section 30 by 30.
Because it stands.
It stands.
He is ready to go by the order of conviction.
Conviction remains there. So, but the state has remitted the on part, that sentence part. So that is the power is there, 432, 433.
430.
So that has they have considered. So the impression that it can only be considered after the disposal of the appeal, that is not there in view of the Honorable Supreme Court decision in number of cases. They are doing it, and from time to time, ordinarily they were doing it on 3 dates. That is on 15th August, January 26th, and 2nd October. But in view of the NALSA guideline, now it's a regular process. So whenever a recommendation is made, it is time to time it is taken, and the order has been passed. And schemes have also come that if you are aged about 70 years or you are suffering from terminal illness, for that also the DLSA secretary is taking steps in filing the bail application in this matter. So orders. So
that technicality.
That technicality cannot. If you want to say something else, you can.
To the merit of the case, my lord.
Yeah.
Admittedly, this is a case, my lord. Prosecution case is by 2 persons. So they have taken a car on rent. They have taken a car on a taxi on rent from Chowda, going to Dhenkanal. From Dhenkanal, again, they persuaded the driver to go to a riverside, to a lonely place, where it is Kanakanagal, my lord, where it is alleged that first of all, they assaulted the PW9, my lord. They threw him out from the vehicles, and with the deceased, they went away, my lord. So my respect to submission before your worship is, so for this present petition is, so for the present appellant is, what are the present appellant is concerned?
No, not went away. They again came back.
Yes.
Because by that time, PW9 was not there. He had crawled to another place. That is why they could not find him there.
Yes.
So the accused persons in that vehicle with the deceased had gone, but again they returned back. That is the evidence of PW9. That is, no?
Yes.
And in the meantime, he was not there because he has crawled to a distance, and but the evidence is there. But then they went away, and on the next day, morning, the dead body was found. It was at a nearby place, and it's a case of homicidal death. That is how we put a pertinent question to the London Council that if the deceased was in the company of the 2 accused persons in the car in that night, and in the early morning, the dead body was found, and it is found to be a case of homicidal death, then under section 106 of the Evidence Act, you are required to discharge your burden that what happened to the deceased when you parted the company of the deceased, and how the deceased met with the homicidal death. But the questions have been specifically put in the accused statement, simply denial by michcho katha na gananti କହିଛନ୍ତି, etc. That is how the case is there.
And the case is stated, my lord, from a point, my lord, when the accused persons were unknown, my lord, they were not named. And the trial court has given a finding, my lord. Admittedly, there is, my lord, admittedly, there was no eyewitness to the occurrence, my lord. So for the death of so for the murder of the deceased, admittedly, the finding is, my lord, admittedly, there is no eyewitness to the occurrence.
Right.
If there is no eyewitness to the occurrence, my lord, then the prosecution has to prove this case by the circumstantial evidence or any other factor, my lord.
Yeah.
If there is no eyewitnesses to the occurrence, my lord, then your lordship will find that the prosecution has relied on the TI parade, my lord. And so far the TI, because they have not named, because they didn't know, they have not named, my lord. So the prosecution has relied on the TI parade, and the TI parade indicates, my lord, the TI parade. It is also stated there are also material to show that a photograph of the accused person was taken before the TI parade was conducted.
No,
That could not
when
be
the
proved.
vehicle was seized from, I think it is Kharagpur or
Kharagpur,
something
yes.
like.
Whatever it may
The
be.
photographs were taken. It's all right, but merely because photographs were taken and it is also required to be taken. Question is that whether there is any evidence or you have brought out any evidence through the PW9 or by any other witnesses that he had got a chance to see the photograph.
Mr. Naik, this is not a case that the accused had only a glimpse to see the accused. The witness had the occasion to remain in the company of the accused for quite long time.
More than 6 hours.
And if at all the photograph is shown to him is immaterial here, because he has every scope to see in every part of the accused.
If they don't know the name, my lord.
Name is not the question.
Name is not the question.
Here, is it name is the question in identity.
And if photograph is taken, my lord, they'll always, my lord, the photograph will be
So
taken.
that
That is not that. That
that's
is
a
enough.
general. Suppose Dokaiti is committed in a few minutes,
That
that is
is
there, and it's a night, but they were in the company of the deceased from, I think, 4 o'clock,
4:30 to 11 o'clock.
11 o'clock. So 7 hours they were together.
They had food.
Various
They take the
activities.
food, various activities were there. And apart from that, they assaulted also. That is the evidence of TW9. So in such a scenario, you cannot say that they got no scope to keep in memory the identity of those persons so that they will not be able to identify. So, and the man identification parade madhya immediately heichi. The after the arrest was made, I think
The persons were also
Arrest
nabbed
was made
from
at 7-9 in Kharagpur. They were produced before the local magistrate on 8-9 and 39 they are produced before the Kamakhanagar SDGM, and on 14th onward the TI parade was conducted. Immediately after the production.
The reason as to why the photograph is taken. If no reason has been assigned as to why the photograph is taken.
No, photograph, because the car was seized from a particular place, and these are the persons from which it was seized. So, in view of the provisions, they have kept it, the car identification, the number, the registration number.
But by that time, if they have taken the photograph of the accused persons, my lord, and the accused persons were subsequently put to TI parade, my lord, there are decisions to show that before the accused persons were put to TI parade, if a photograph was taken.
We do agree, yes, we do agree.
That
In
is
certain circumstances, what your submission is correct. But this case, the factual scenario in this case is altogether different. The persons have come, hired the vehicle,
Yes.
interacted with the owner,
Yes.
the driver,
Yes,
there is bargaining,
Yes.
and finally the higher charges has been fixed.
yes,
Then, so it took lot of time.
yes.
Then they had the vehicle, they came with the vehicle, stayed in different places, took food, different activities, then assault, then they have gone away. So the time,
But within this time, my lord, they had no opportunity to know the name.
So
not
name-
necessary, name is
So
not
That's
necessary.
not material, my lord. I agree. But once they have not uttered the name, my lord, then the only alternative is to find out their
Person.
to TI parade. And if the TI parade is vitiated because the
Why
photograph.
What is the
it will be
question
vitiated?
vitiated?
Why it
No.
will be vitiated?
Because my lord, the photograph is taken and the IO has not explained as to
No.
why the photo was taken.
But he has explained that why he took the photograph. He said that I seized the vehicle and accused person, this accused was there. that is how I took the photograph of the vehicle
Yes.
as well as one.
My lord,
And you have put the questions to the that particular witness PW9.
Nine.
Various questions
Yes,
have been
confronted. Lord.
confronted that you are shown the photograph. He has
Denied.
stated no, nothing has been brought out. That is why if you would have been successful in eliciting that yes, those photographs were
Have been shown to
that
him.
would have something to argue, but you are unsuccessful in bringing such materials in the cross-examination. So we cannot just imagine in view of that photographs where it might have been shown. So that is not the case here.
But after they departed, after one person was assaulted and thrown out of the car, and after the deceased accompanied these two persons, my lord, and thereafter there is absolutely no evidence, either eyewitness or anybody, my lord, as to what happened to the deceased, my lord. Can we presume, my lord, that two persons must have been assaulted?
No,
So
because
only
of
presumption, only a presumption, my lord.
what 106 says, that suppose the husband and wife are there in a particular room and they were last seen together. On the next day, the dead body was found in that room.
And in the same proximate area where they
Yes,
had
that is
taken a,
most important.
Two
If
persons are
the
there.
time gap would have
only
been
two
long,
persons were
And
there.
had it been one person's minor, then it would have been.
So it's not there. So 34 is there.
34 is there.
Two persons are there, and
You are not
34 is there.
advancing the case that accused is not telling
Yes.
that after some time I got down from the car. So his plea is totally denied.
No, it
So either we disbelieve PW9
after
or if we believe PW9, then you are required to explain
Yes.
what happened to the deceased.
after they left the first place, my lord, can we presume, my lord, it's a case of under 302 and conviction is like.
No. The dead body is in the first place.
Can you presume? And one weapon was seized, that is from the co-accused, the other accused, my lord. And there are evidence to show that all along he was assaulting, my lord. That was seized from him, my lord.
No. Both have asserted. No, kindly see the see the evidence.
Pen of page number 140, please.
No, see evidence.
I'm asking you to please.
Lordship, in the
Page 139 would be relevant.
Lordship, in the examination in chief, he has stated that both the persons were assaulting us, Your Lordship.
One, no, individually has said.
Lordship. Thereafter, he has
Can you read?
Thereafter, he has clarified in page number 146
Who has clarified?
the injured witness, Your Lordship.
Who has?
138.
What was the scope of clarification?
PW9, Your Lordship. PW9, who is the injured on whose assault has taken place.
Yes.
It is not a fact that I am deposing falsehood regarding accused Balaji assaulting me and Sudarshan assaulting Abhay inside the vehicle. Your
It is
It is not a fact
not a fact.
that I am deposing falsehood
Yes.
regarding.
Yes.
Yes.
That means confirming his evidence.
The appellant has not assaulted the deceased. That is what he is saying. That Balaji assaulting me and
Yes.
Sudarshan assaulting Abhay inside the vehicle.
Yes.
So the appellant had never
Oh,
assaulted
that
the
way.
deceased.
So that 34 is there, madam. What do you have to understand?
And
It is a
section
common.
30 Section 34 does not say that each one of the accused must assault the deceased. They have to share a common intention, and in furtherance of common intention, if one is committing the crime, then the other will be liable. It is not that both of them should assault. It 34 says about the common intention, not that each of them should assault. That is so many decisions are there.
Investigating officer also says that the PW9, he has not specifically stated before me.
A sporadic sentence of a witness in a cross-examination will not in any way impair the substantial evidence.
Investigating officer, and he says that he has not said a fact of the assault before me.
Who?
The investigating officer.
Find out.
He has not, page number 179 of the paper book, Your Lordship.
179.
79.
We'll see. Yes.
He had not.
No, para.
First paragraph.
First paragraph.
First para, third line.
Hmm.
he had not specifically stated before me that accused Balaji assaulted him inside the car
No,
and
which
dragged him.
179 you were saying, no?
179 of the paper book, Your Lordship, para 10 of PW 16.
I had examined Samir. He had not stated for me that the accused Sudarshan. Where from we are reading?
Bishop 179, the cross-examination, the first para.
Yes, he had not stated for me that accused
The
Sudarshan.
second line.
The second line, Your Lordship.
He had not
He had
specifically
not
He had not
stated.
specifically stated.
But
Who?
he-
Acha, huh.
It says PW 9, Your Lordship. He has not specifically stated before me that.
Not specifically stated.
Yes, Your Lordship. He is not specifically stated before me that accused Balaji.
So come to 161.
Your Lordship.
Come to
Your
161.
Lordship, please, permit me to complete this sentence.
No, you come to first 161. Let us see if it is saying it. He is saying it is not specifical. Then what is the statement? Can it be taken as a contradiction? Then we'll have to see. Kindly come to 161. We'll see 161 then. What is his statement before police?
Your Lordship, the
161 is.
Your Lordship, a 161 statement when the IO has stated and
You see,
The IO is saying he has not specifically. We want to see what is the manner of statement.
161
This statement
cannot be
is
relied on. 161 statement, even if he has said, cannot be relied on. It can be used only for the purpose of.
Yes,
That's,
where are he?
court has power to see that when.
Can't we
Yes,
see?
in-
But cannot be
You
relied.
cannot
No,
prevent. the
can't we
court-
see?
When such a situation arises, to what, the
Can
court has
compare,
power
can
to see
compare,
that.
but
No, we understand that 161, we are not going to use that as substantial evidence. That is it expected, Mr.
Direct
Naik,
proof of common
that the court is
intention.
expecting 161 to read in evidence? It is to be seen when such a question is put and an answer has come. Let us see what is that. Because you cannot take whatever the sentences have been said by the IO is final as vis-a-vis the statement.
one important aspect, if he has not specifically stated, my lord.
That
then-
is the reason why it
You want to
is stated
see
that
that?
once you confront 161, you should mark it as an exhibit. That like X, and when the IO comes, it should be proved so that the court can see it. And if you are in trial court, it is not being done. That is why we can see it, that what is the real statement in such a situation. Division bench decisions are there, two division
Lots
bench
can see.
decisions.
Lots you can see them.
Can't we see it?
yes, sir. Correct, sir. Okay, fine.
LSAT and
ठीक है बना
इतने दिक्कत जाएगी बाहर तो देखूंगे ना बाहर तो देखूंगे अजय इटे ये तो नहीं LSAT record is there. Right.
Anything else?
Proceed.
Anything else?
Your Lordship, only the final thing about this statement is, Your Lordship, it can be taken two ways, Your Lordship. But since it is that the one that is the view that is favoring me, Your Lordship, that should be taken into consideration. And also other witnesses in front of whom I have stated that I had been assaulted, the IO has stated that those witnesses have also not said that they had seen injuries on me. So,
All right.
Your Lordship, because this
So the evidence of the injured witness is not to be
should
believed.
not be relied upon.
Two witnesses have consistently stated that you two were in the company of the deceased and those are PW 9 and 10. And if we find that the evidence of these two witnesses have not been dislodged and you were in the company, then the period for which all of you are together, the fact that one of them, that is PW9, was left out, and thereafter you two were only in the company of the deceased in that car, and the dead body was lying at a close distance where PW9 had seen all three of you in that car, and it's a case of homicidal death. So it's a if otherwise the evidence is not disbelieved, then you are required to explain that that is the burden of proof you are to, because that was within your exclusive knowledge that he was with me and his dead body was found at this place. So what happened to that? If you say that no, I have no knowledge, I have left the company of the deceased, only X was in the car, all these things are to be told by you. Otherwise, it is to be used against you in view of section 106.
More particularly when the vehicle would not have been seized from your custody, because vehicle has also been seized from your custody.
That has been seized from the co-appellant. That is what.
Oh.
All the evidence are there.
Co-appellant is
Your Lordship, may hear me for a moment. That is
You're
what
not
is our
able to-
contention, that we were
Alright.
last seen together with the deceased along with the appellant. That is an admitted fact. We are not disputing that. But thereafter, none of the circumstances are connecting me to the death of the deceased, Your Lordship. And moreover, Your Lordship, the PW9 also, Your Lordship, he has specifically stated that I was never assaulting the deceased, Your Lordship. So it cannot be ruled out that there was a possibility that
34 requires that all the persons, all the accused persons
Individual.
should assault.
Yes, Your Lordship.
That is how 34 would be attracted. If you think so, then fundamentally it is incorrect.
Your Lordship, but the injuries that have been inflicted, that has to be inflicted by both the appellants, Your Lordship. Here
It
the
is not
injuries-
necessary that both the accused persons should assault. You can read 34 carefully and this decision on 34, what requires to be proved in a case of 34. Even the presence of that person also is not necessary. If suppose the accused persons are planned, they have a common intention, one man is here, he has diverted the deceased to that place, the deceased was taken from there, he was handed over. So this is common intention. So many decisions are
Formal
there.
intention, that is also no direct material matter to show, except their conduct that they had to work on together. Only, Your Lordship, you can presume only, my Lord, since both of them had accompanied the last man and subsequently his dead body was found. You can only presume. But what has happened after these two persons accompanied the deceased?
That you are to say,
Hmm.
that is how 106 is there. That you are to say, what happened to the deceased, how his dead body was found at such a close distance. Suppose somebody, ଆଜି ଜଣକୁ କଟକରୁ ଆପଣ ନେଇକି ଯିବେ, 4 ଦିନ ପରେ ତାର ଡେଡ୍
Yeah.
ବଡି କୋରାପୁଟରୁ ମିଳିବ, ଆପଣ କହିବେ the possibility of some other persons coming
In between.
contact with the deceased in the between this period cannot be ruled out. That's the matter is different. But here is a case, the place where you were last seen with the deceased, in the very close proximity, the dead body was lying and it was a homicidal death. And the car was not found, you were not there. So that is how it requires that some kind of explanation should come, and that is your burden to discharge. The prosecution has discharged their burden by proving through the evidence of PW9 that both of you are in the company of the deceased in that car in that night at about 11 o'clock, and that the dead body was found at a close distance. It is a homicidal death. This thing they have proved. Burden shift to you to show that when you parted the company, how the deceased met homicidal death. That is 106. And if you do not discharge the burden, then certainly it would be used against you.
The last scene also, my Lord, the boy, people two who has seen them from Nava, he has not supported the prosecution case. The last
Who has
scene,
not supported?
One, PW1.
1 and 2.
We are only focusing on two witnesses, PW9 and PW10. That's all.
I'd love to.
People one had occasion to see them in a dhaba, my lord, while they were taking the dinner. He has not supported the prosecution case.
No, every witness need not support the prosecution case.
This is a part of the last scene, my lord. This is a part of this is a material, my lord, which was adduced by the prosecution to prove the last scene, my lord. But he has not supported that both of them. He had seen both of them at the dhaba. He has said, my lord, if none of the accused persons standing in the dock had taken food in our dhaba within the last 3.5 years, I cannot say if I was exemplary.
So you are filing the written note of submission today?
Yes, ma'am.
Please file. Citations also you are filing.
I may be permitted to place 3 citations.
Yes. You have received the memo of citation and written note of, please give it to it, copy to.
Your Lordship, only one final submission
Yes,
is
yes.
to the PI parade, Your Lordship.
Yes.
We accept that, Your Lordship, photographs had been taken, Your Lordship, and that had been taken to be submitted in the court, Your Lordship. What we say that beside the photographs of the appellant being taken with the car also, Your Lordship, they have seized our photographs from our house. They have not written in the case diary, Your Lordship, the purpose of taking such.
Case
photographs.
diary.
Yes, Your
They
Lordship.
have not mentioned it in the case diary.
Mentioned
Have
it.
you gone through the case diary?
Specifically stated.
Who?
Ayub has specified.
No, just,
All right.
madam, just a minute. Which appellant was present with the car?
Both the appellants.
No. Both the appellants were.
Yes.
So, photographs were taken because the car was seized and both the appellants were, that is the evidence of the IO?
Before that also photographs have been taken.
No, I think after
Photographs have
the,
been seized, Your Lordship,
no,
from the house of the appellant, Your Lordship.
I think the evidence is that
Before
when the
that,
car was
after the
seized,
recovery of the car.
that is the evidence.
Number 177, Your Lordship, para 8.
Paragraph 8, the photograph was of Babuli alias Sudarshan.
Yes, Your Lordship.
You are not Babuli,
No, I am.
you are Balaji.
Balaji.
That's wrong. We come to that particular line, 177, fourth line, I seized the photographs of accused Babuli alias Sudarshan from his house at the time of my visit to the lodge. Right?
Yes.
Now you come to the other car. Seটা সে কোন লাইন আছে ওটা দেখছিলাম
178, first line.
178.
I had taken photograph.
I had taken the photographs of Babuli,
Babuli and Babaji.
Babaji,
The car at
along with the car
Kharagpur.
at Kharagpur.
The photographs
So,
of the
see,
accused.
ଅନ୍ୟ କୌଣସି ଯୋଉ ଫଟୋଗ୍ରାଫ ଆପଣ କହୁଛନ୍ତି ନା ତା ଘରୁ ବି ନେଇଥିଲା କେବଳ ଫଟୋଗ୍ରାଫ ନିଆ ହେଇଥିଲା ଯେତେବେଳେ କାରରେ ମାନେ 2 ଜଣ ଇଏ ହେଲେ ତା ପୂର୍ବରୁ ଯୋଉ ଆକ୍ୟୁଜ୍ଡ ର ଫଟୋଗ୍ରାଫ ନିଆ ହେଇଛି he is not before us now, he has been released prematurely.
Your Lordship, that is what we are saying, Your Lordship, that they have IO has then specifically stated, I have not mentioned in the case diary that I had taken precaution to the effect that the accused persons are not being exposed to the witnesses prior to the FIR, Your Lordship. Why prior to the TI parade?
You see your cross-examination in paragraph number 12. You are putting a question that after arresting the accused persons, I had given the photographs of the accused in the newspaper as well as TV for wide publication. Have you proved anything?
What I am contending is,
No,
it is not
when you are
necessary.
putting a suggestion like this, is it a bald suggestion or there must be some material that yes, the newspaper is there? You could have shown
Yes,
that
sir.
this is the newspaper in which the photographs have been, or this is the TV on this date at that point of time it was published. Just give a suggestion that photographs are newspaper e bahar thila, TV re dekha hitila. there is nothing.
No, Your Lordship, what we are contending is it is not necessary that the photographs have to be shown to the appellants, sorry,
Huh?
injured person, Your Lordship.
Then,
Even if the photographs has been taken, Your Lordship, the
Yeah.
investigating officer has to assign a reason
yeah,
as to why he has taken the photographs, and such photographs have
it is a
not.
part and parcel of the
Investigation.
But there are
Wait,
judgments.
no.
Judgments wherein it is said that
You will file it.
photographs
You
of
find-
accused persons taken after arrest, no reason assigned us as to why such photographs have
No.
been taken.
In the event the person has not been identified, the name not known, the gesture, posture, identity of the accused is being disclosed to the investigating officer, then how the person will be detected? His sketch is not to be prepared. The photograph is not to be taken.
The question
We'll
has
see.
not arrested.
All
me.
right.
They have arrested.
You'll
me.
file it. You file it. We'll see.
We have taken the appellants.
All
to
right.
the
Madam,
court
kindly
also.
file it. We'll see. We'll see. One is the statement of the IO that you have pointed out. The other one is with regard to the photograph. Yes. All right. Kindly submit the written note of submission. We'll see.
And also, it is the specific statement that when they were being produced in the court, no caution was taken to hide their identities or hide their faces. TI parade has been conducted 1 month almost 1 month after. The IO has examined the injured witness 4-5 times, Your Lordship. The IO has specifically stated that I have not taken any caution to hide the identity. So the possibility that he has exposed the identity also
Cannot be ruled out, right?
Your Lordship.
We'll
And Your Lordship, I pray that the view that is favoring me has to be adopted.
Correct.
We
So this
got
is
some really old decisions, Your Lordship, where it is stated that mere taking of photographs also makes it unreliable, Your Lordship. Although the
all right. You jot down these three points in your written note of submission. We'll take that.
there is, find out in the CRPC as well as in the, that police rules, it says that if a stolen property is seized from the possession of a person, the photographs of that stolen
Taken.
property
Has to-
and the
40.
person from whom it is seized, that
Yes.
is to be taken.
Yes, sir.
That is there.
I'll find.
Your Lordship, may this please find
Because it becomes the stolen property.
Yes,
That car becomes the stolen property. It belongs to PW 10.
PW 10.
PW 9 was driver and they have taken that.
Yes.
So it becomes the stolen property. And if such property was recovered from at a different places like Pigeon, what is it?
Correct.
Correct.
Different state.
Then '94 CRPC deals with that search of the place suspected to contain the stolen properties also. Then So there is another provision 101 also says disposal of the thing found in search beyond jurisdiction. So obviously it is beyond jurisdiction. So then what is to be done? That list is to be prepared. The thing is to be so and so, or deals with it. And also go through that police rules. Police rules ରେ ଆଉ ଟିକେ detail କରାଯାଇଛି ସେମାନ
Yes.
ଟିକେ ଯେ ଜବତ କଲା ପରେ ଯୋଉ ଚୋରି ପ୍ରପର୍ଟି ଗୁଡାକ ସେମାନେ କଣ କରିବେ?
But that also, I guess there is the stolen property, the photographs of the stolen property has to be taken. The photograph of the alleged owners should not be taken.
Stolen property and the person from whom it was seized.
Seized. That is very.
That is there. You read it. Don't argue when you are telling that that is there. So go through it.
Because
Don't.
then they should have taken only the picture of Sudarshan.
Hypothetical argument without verifying the books, it should not be entertained. When we are telling that it is there, it is there. You just go through the police rules and you will find it. That if a person is found in possession of the stolen property, what is to be done by the investigating officer?
Regarding that photograph only, may I just be permitted to please one para from the judgment, Your Lordship?
We'll file it.
File will see that.
I
Well,
wanted to hand over the judgments as well as the.
You are forgetting that those cases are dokaiti cases. The dokaiti took place in the night. The accused persons might be seen by the inmates for a few moments, and they must be in a state of anxiety. And in such a scenario,
Yes.
the entire evidence is assessed
Yeah,
in
fact.
addition to the taking of the photograph. The factual scenario in this case, because of the length of time,
Yes.
they were together, right from 4 o'clock till 11 o'clock, going to different places, taking food, this, that,
Interaction
and
and all that.
assault, all these things. So, so long time is there to keep in memory. And even if we disbelieve also
Yes.
that TI Parrot report,
Yes.
then also the court identification
It's enough.
cannot be discarded.
But the independent witness, they say that they had not seen. And the injured witness says that they have not been assaulted by me, Your Lordship. He has not been assaulted by me, Your Lordship. Though he has been examined 3 to 4 times, Your Lordship.
Hmm.
Take it as your point. We'll see. We have noted it.
Anything to you want to say?
Kindly see the circumstances which led to the
Conduct.
conviction. I'll place the circumstances which led to the conviction of the accused persons.
Yes.
Coming to the judgment.
Yes, sir.
Which
Page
paragraph?
45.
Page number?
45 of the paper.
45.
Yes, sir. 45, paragraph 10. It starts from page 45, the relevant portion will be 45. May I please?
The circumstances have been enumerated there.
Yes, sir.
And it has been mentioned that there are as many as 14 circumstances,
14 seconds.
right?
Yes, sir.
And
And shortly place the circumstances as well as the.
it's all right. We have
corresponding-
already heard it, madam. If you want to just add anything, you can do it.
So my submission was that since 4:30 to 11 o'clock, they are in the company of the accused persons. So TI Parrot would not have been necessary at all. And for
Yes.
that, they got arrested on the second night. The present appellant found injured, and thereafter the FIR was lost. On third morning, the dead body of the deceased was found in the nearby places. On 7th, at Kharagpur, the accused persons along with the car was seized at Kharagpur, Your Lordship.
Hmm.
On 8th, they produced before the local magistrate at Kharagpur, Your Lordship. Thereafter, on 13, they brought out to the Kamakhanagar STGM. Thereafter, immediately the TI parade was conducted, in which the PW10, who is the owner of the vehicle, they identified the vehicle as well as the accused persons, Your Lordship. That somehow complete the entire chain of circumstances, coupled with the evidence of doctor, which says the injury suffered by the deceased is possible by the Bujali, and the death is a homicidal death, Your Lordship. That takes care of the entire case to me. And immediately the PW9 who got injured in a second night, Your Lordship, he crawled up and he went to the nearby village. And PW3 and PW8 who took care of them immediately. Before them, he narrated the entire incident immediately. As a result of it, the FIR was lost. So there is no time gap or there is no occasion for anyone to array these persons as accused persons.
And also,
The Lennon trial court seems to have not only enumerated the circumstances but has discussed each
Yes,
of the
in
circumstances
each of the
and has given his finding
findings.
that which circumstance is to be accepted and what is the reason for accepting that
Yes,
circumstance.
sir.
First circumstance is beyond Google. তারপরে করেছি 2 to 7 and 14 କୁ ନେଇଛି টেক অফ করেছি এই হଉଛନ୍ତି
That is not meticulous.
there is, however, one circumstance only that has not been dealt by the trial court. That is the timing of the injuries, Your Lordship.
No, that has been, Your Lordship, kindly see the doctor's evidence for that.
Yeah, the doctor's evidence says, Your Lordship, that is PW5, Your Lordship, who has examined the injured, Your Lordship.
No, and Your Lordship, kindly see the.
He states, on the date of police requisition at 9:55 p.m., I examined Samir Kumar Behra, son of Dusasan Behra, Your Lordship. It is 9:55 p.m., Your Lordship. In second page, he says, all the injuries, sharp cutting weapon, which was caused by the impact of blunt so and so, the injuries are within 12 hours, Your Lordship.
That has been answered in the lower court judgment. That shows that the lower court has explained that usually the person who got admitted, before that he got examined. Only when it is necessitated, then only got admitted. That's why the timing of that examination as well as the injury would be difficult.
Your Lordship, even if taking more than 12 hours also, this does not stand, Your Lordship. The manner of injury, it is there, Your Lordship, but the timing of the injuries has been correct.
That is different, according to
You should
Yes, Your Lordship,
PW4.
because he specifically says, PW4 says about the death of the deceased, Your Lordship.
That is how we are here.
No, Your Lordship, we are here for 307 also, Your Lordship. And we are relying entirely on PW9 to convict the appellant, Your Lordship. So when the appellant is saying that a time of injury is not matching with the case of the prosecution, and it is not that the doctor has given a time gap, Your Lordship. The doctor is specifically saying that within 12 hours, the injuries are so fresh in nature that he is saying it is within 12 hours, Your Lordship. The whole cause of action had arose at 11 p.m. on the previous night, Your Lordship. More than 24 hours. In such a scenario, जब मुझे को रात्रि 11 रू मारी लेनी, ताले more than sufficiently more than 12 hours होची. Doctor bracket भी देना थी, conclusively कही चंती injuries are within 12 hours.
Cross examination में किसी रखे ना दे. PW4 में
He has stated something very conclusively.
So PW4 paragraph 4, I'll place the PM doctor. Time since death at the time of occurrence is of 13 to 36 hours.
That is what we are saying, that the time of death and the time of injuries being inflicted on me is different.
right.
Both are not the same. And that is why the body also has been decomposed, found to be in a decomposed condition, because that 36 hours of time gap also, Your Lordship.
Actually, what has happened, this PW5 This is not PM, it should be AM. You see the evidence of the that injured witness in page number 140. At about 9 in the said morning, police brought me in the said tracker to Dhenkanal hospital and I was given treatment in the hospital, getting admitted to the hospital. So this is eta khali PM eta hochi page hochi 140 PW9.
Yes.
It has to be.
Yes.
अरे बेनिफिट कौन एटा भूलले टाइप कर देइछि से ताको देखिनी से तार रिक्वेशन रे भी सेया थिबो जे न रिक्वेशन दा केते देखना दी
Exhibit 4.
एग्जिबिट 4 देखो ताको आईओ रो एविडेंस हो जा सी नेकिनी गला ताको सकाळे 9टा बेले नेकिनी गला
रात्रि तो इंसिडेंट केतळ नाही तो स्कोप नाही रात्रि
9टा
there is no scope at 9:55
নাই এই ঘটনাটা হইছি 2 তারিখ দিন
হ্যাঁ
3 তারিখ দিন মানে 3 তারিখ রাত 3 তারিখ
9:55
রাত্রিরে এটা পিএম টা ভুল হয়ে যাচ্ছে এটা ভুল হয়ে যায় এটা দিস সেইপাই যে ମୁଁ ଏଇଟା ଦେଖିଲି ଏଠି ଲେଖା ହେଇଛି କ୍ଲିୟରଲି at about 9 in the said morning police
Acha,
brought me in the said tracker to Dhenkanal hospital and I was given in the treatment in the hospital getting admitted in the hospital. This is the evidence of the PW9 the NGO and IO must have also stated like that. IO कितने नंबर साखी 16 ସକାଳ 7:30 ରେ ରିଟିନ୍ ରିପୋର୍ଟ ପାଇଲା ସମୀର ଠୁ ହେଲା ଏବଂ ତାପରେ ତାର ଏଭିଡେନ୍ସ ଦେଖନ୍ତୁ ପାରାଗ୍ରାଫ ନମ୍ବର 2 ରେ
Exhibit
I found the informant to be serious for which I removed him to district headquarters hospital paragraph 2 page 172 ତା ପୂର୍ବରୁ କହୁଛି ଯେ ମୁଁ 7:30 ସକାଳୁ 7:30 ରୁ ରିଟିନ୍ ରିପୋର୍ଟ ରିସିଭ୍ କଲି ଫ୍ରମ୍ PW9 କୋଉଠି ରିସିଭ୍ କଲି ନା ଭିଲେଜ ମଛିଆରେ ହେଲା 171 ରେ ହେଲା ଏବଂ ତାକୁ ରେଜିଷ୍ଟ୍ରେସନ ହେଲା ସୋଆନସୋ ଦେନ୍ ନେକ୍ସଟ paragraph number 2 during investigation I found so Behera to be serious for which I removed so and before SIPO I examined so requisition etar
Exhibit 4, page 159 of the report.
exhibit 4 hochi tar requisition to 4 ta bhar kona di ta de
লেখা আছে 955 এর
exhibit 4 ta bhar kona exhibit list ta kono
that
list
that is an address to the officer in charge
exhibit
PSC.
4
Page 159. Dated 3/9/94, 9:55 a.m. Yes.
9:55 am ये PM टा भूल लेती देख रहे ना साइड लिखा है 9:55 am लो ओपिनियन देज ये PM टा भूल लेती 8 caught in wounds and 1 bruises. Close कर दबा
I'll place just one paragraph of a judgment.
Which paragraph? Two page, two
No,
paragraph.
so I'm not a judgment. I'll just place a citation.
Written note ଦଉଛନ୍ତି
I'll file a written note regarding that stolen article as well as the provision regarding the seizure of it.
Ajit देवे ना it'll take time
I'll take one day.
kali
A judgment of knowledge.
See the police rule.
Yes, I'll
ଏଇଠି ଦେଖନ୍ତୁ police rule ଟା ଦିଅନ୍ତୁ
just
এটা কোন জজমেন্টের কোন এটা ধরছেন?
Paragraph 6 would be relevant.
Alright, we'll see that.
Yes. May I please? We have considered the respective submission and the evidence on record. There is no eyewitness to the
No, no, you are reading out.
Yes.
Please read it again.
We have considered the respective submission and the evidence on record. There is no eyewitness to the occurrence, but only circumstances coupled with the fact of the deceased having a last sin with the appellant. Criminal jurisprudence and the plethora of judicial precedent leave little room for reconsideration of basic principle for invocation of the last sin theory as a facet of circumstantial evidence. Succinctly stated, it may be a weak kind of evidence by itself, but to found conviction upon the same singularly. But when it is coupled with other circumstances, such as the time when the deceased was last seen with the accused and the recovery of the corpse being in very close proximity of time, the accused owes an explanation under section 106 of the Evidence Act with
That is
regard
what-
to the circumstances under which the death may have taken place. If the accused offer no explanation or furnishes a wrong explanation, abscond's motive is established and there is corroborative evidence available inter alia in the form of recovery or otherwise forming a chain of circumstances leading to the only interference for guilt of the accused. Incompatible with the possible hypothesis of innocence, conviction can be based on the same.
It is what Lordship has been
This
insisting
came from
on.
the lordship. And there are another judgment for lordship. It says on the basis of a sole eyewitness, the conviction can be based. It's a subtle law, Your Lordship.
That's-
Still, I'll just hand over the judgments. I've marked the paragraphs in that.
Reserve করবো।
Hmm.
দেখুন, this matter, though the judgment was reserved on 1/7/2025 after hearing the Lennon Council for the appellant, Miss A. Mishra and Miss Lennon Additional Standing Counsel, Miss S. Devi. But yesterday, Mr. Dharanidhar Naik, senior advocate, made a mention in the first hour to raise this matter under the heading of to be mentioned to argue some points and also to file the written note of arguments and citations. Accordingly, the matter was directed to be listed today under the heading of to be mentioned. Stop. Hard Dharanidhar Naik, senior advocate, Dini Mishra, Miss A. Mishra, senior advocates, and Miss S. Devi, additional standing counsel. The written note of submission, so also citations have been filed. Upon file karata by the Lennon Council for the appellant. The Lennon Council for the respondent submits
I'll file a repeat
that the written note of submission will be filed by
By
tomorrow.
by Monday.
Filed
I'll file it. I'll file it tomorrow.
Filed by. You should think that we have got 2 holidays so we can write the judgment. So
I'll file it by
tomorrow. Hearing is closed and judgment is reserved. So,
Much.
Diva. Sure.